Ladies and gentlemen, thank you for standing by. Welcome to the BIA Knowledge Leadership webinar. During the presentation, all participants' lines will be in listen-only mode. Should you wish to ask a question during the presentation, please use your chat feature located in the lower left-hand corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded. Thursday, September 15, 2016. I would now like to turn the conference over to Mark McDonald. Please go ahead.
Thank you very much. Welcome everyone, and thank you for attending today's BIA Knowledge Leadership Series. Backed by popular demand, today's presentation is the Ethics of Legal Hold, presented by BIA CEO Brian Schrader and Barry Schwartz, the head of our advisory services. We have a very exciting agenda today, so I'd like to get right to it. But first, I want to remind people that the course has been approved for 1 hour of ethics credit by the state of Texas. Attendees are required to provide their name and bar number at the end of the program in order to receive the credit. For those who are self-certifying, your CLE in states with verification requirements will provide 3 different numeric verifiers during the course of the program. If you happen to be listening and not viewing the slides, Barry Schwartz or Brian Schrader will prompt you for those numbers. You'll be asked to supply those at the end of the survey, and then we will be sending you your documentation accordingly. At the end, there's also a survey for you to fill out. We would love for you to have the time to respond to those. During the survey, you'll be have an opportunity to request a copy of the deck and also to request the most recent copy of our version of the Federal Rules of Civil Procedure, the amendments to the Civil Procedure Rules. And I'll announce that again at the end of the webinar to remind everybody. But without further haste, Barry, I'm going to pass it off to you.
Okay, thank you, Mark. This is Brian, and we'll go real quick here through the slides that give the backgrounds of Barry and myself, and we'll get right into the topic. So, again, thank you everybody for joining us today. And like Mark said, don't worry about trying to write down all the stuff. This is a very packed presentation. It's got a lot of case law, a lot of citations in it. You don't have to worry about taking any notes on that kind of stuff. Just complete the survey at the end, and you'll get a copy of the PowerPoint presentation. You'll have a chance to request that. So just to give you an idea of what our discussion is going to be like today, we're going to be talking just briefly a little history of legal holds in general. We're going to go over the ethical side of this, which is really the FRCP and the ABA model rules, to talk about where the kind of ethic requirements come from and how they attach to the legal hold process, really kind of the heart of what we're talking about here, as well as some cases that go along with that. Once we do that, we're going to talk how to actually issue legal holds. We're going to start out with going through some case law to talk about how to properly issue legal holds. By no means a complete and overview of every single case out there. That would take us days. But we highlight some cases that really point out some of the more important parts of the legal hold process. And then we'll finish up with what everybody probably is most interested in, is the practical guidelines, the how-to. How do you actually issue a legal hold? What are our recommended steps to make sure you're hitting all those requirements and protecting the organization? So that being said, let's start out first with the little history of, why are we talking about legal holds? And here's our first verification number. For those of you tracking, the first verification number is 212. All right. So one of the things I want to start out with is making sure we're all on the same page. We're talking about legal holds. A lot of times the concept of issuing litigation holds gets blended into the idea of preservation of data. And actually starting to preserve data. And while the line between the two are becoming more and more kind of combined over time, or the two processes are becoming very combined, and we'll talk a little bit about that later, what we're really focused in on is the actual process by which the organization notifies potential custodians to preserve information in electronic paper or other in anticipation of litigation. And so it's really that notification. How do you get your custodians notified? How do you make sure that they understand what their obligations are, and how do you make sure that you remind them over time? And that's what our real focus is today. One of the questions that I would get a lot when we would have these talks is, why are legal holds in such focus? Why is it that in the last several years if you look at the sanctions and case law around e-discovery sanctions, really one of the biggest areas that everybody, or that all those decisions really kind of focused on were these early steps, the early legal hold process. And why is that become such an important part of the overall e-discovery process? And I like to point to kind of two cases that really brought it up. The first, of course, is the Zubilake case back in 2003, the Zubilake 4 decision. I assume everybody's pretty familiar with the Zubilake line of cases. It was really kind of the first, I guess, e-discovery Bible, really, you could say, that a whole set of cases that were very well written by Judge Shinlin that went through all the different aspects of e-discovery and really kind of laid the groundwork for how the industry moved forward for a long time. And in that, she addressed, among a lot of other things, the idea of litigation holds, and that litigation holds needed to be issued and how they needed to be issued and when they needed to be issued. And even though it wasn't the main focus of that particular decision or the overall line of cases, it was really one of the earlier mentions of litigation holds with respect to e-discovery especially. Now fast forward later, 2010, the Pension Committee case, also by Judge Shinlin. Now that case was later dialed back a little bit by the Second Circuit, but what Judge Shinlin said in that case was if you didn't issue a written legal hold, it was de facto negligence. And so it made a big splash. And that was the first time a judge had really come out with that kind of black line or black letter law that laid down the challenge that said basically you do not have a written legal hold and issue it to your custodians on time as soon as you have a reasonable anticipation of litigation, then you're going to face consequences for it. Now the Second Circuit dialed that back and said, well, what about the company with no employees or the company with 2 employees or all these other circumstances? And a lot of people read that Port Authority case by the Second Circuit as really dialing it back and saying, oh, you don't need to issue a legal hold all the time. That's not what the Second Circuit said. The Second Circuit said we're not going to have such a bright line rule. We're going to look at the totality of the circumstances. We're going to look at what's going on in the case and see whether or not the steps taken to issue a legal hold or to preserve data in that particular case met the requirements. So even though the Second Circuit dialed it back, and I agree with what the Second Circuit said, there are exceptions to every rule, but the Second Circuit made it very clear that legal holds are very important. And the reason we bring up the Pension Committee case is because it's shown a light directly on litigation holds, and that case was very much about that. And it was such a big splash in the industry that it raised that issue up to a level that hadn't really been focused on as much before. And so that's really kind of why litigation holds and legal holds have been, in my humble opinion at least anyway, in focus so much. Now, where this gets into the ethics side of the case is after that kind of highlight of the Pension Committee, you started seeing more and more cases talking about outside counsel's responsibility when it comes to legal hold. The Palmieri case, for example, was a case where the outside counsel instructed the CFO to issue some legal holds, really didn't oversee that process, and of course the non-lawyer CFO didn't do a very good job because there wasn't an understanding there of what should really be done. And so even though the court there sanctioned the party with adverse interest and attorney's fees, the actual party itself, it kind of laid the groundwork. It laid the fault at the foot of outside counsel. It wasn't a direct sanction on outside counsel, but it very clearly set up potential ethical or even malpractice issues for the attorney to deal with because the court laid all the blame right there. Another one that came out was one that I found very interesting and really on so many different levels was the Suarez case here. The court criticized the U.S. Attorney's Office for failing to issue a litigation hold to the FBI for 7 months after the onset of an investigation and had a spoliation instruction because of it. Now, of all places, you would think the FBI wouldn't need to be instructed on how to preserve data, but the court, again here, not only kind of brought that issue up, which was very interesting in and of itself, but also, again, laid the blame and the responsibility for that at the feet of counsel, not at the feet of the actual party of the case. And then the next step was we started seeing cases where counsel themselves are being increasingly targeted. In the FDIC versus Malik case, this was a little bit of a different case because the law firm that ended up being the kind of central to this issue had represented a party on banking transactions, and they hadn't done anything to retain their data, their information, and the court used the same kind of legal hold ethics and guidelines and ethical responsibilities that Barry will get into here in a minute to really note that the firm had an affirmative duty to retain this information under the professional responsibility and attorney ethics rules. And so again, you start seeing this issue of preservation of data and legal holds and litigation holds. I'll use legal hold and litigation hold kind of interchangeably. It's the same thing. Again, being laid at the foot of counsel, albeit in a slightly different way. Now, the next case, the ProCaps case, it was really one of the most significant, and it came along in 2014. And what that case did, not only did the court sanction the party, but it was the first case that we saw at least where the court actually sanctioned outside counsel as well. And you'll see here from the quote, not only did the court sanction outside counsel, but it went to as far as saying that the firm should do an internal investigation to figure out which attorneys were directly at fault and look to have those individual attorneys pay some or all of the sanction as well. And so, this was the first time where we saw not only was the blame being placed there, but the sanctions were being placed there as well. So it dialed up that kind of responsibility. And then again, in the Brown versus Tellermate case later on that year, was a very similar thing where counsel was shown to be deficient in their obligation to really issue more than just a general directive. They couldn't just say, oh, do your legal holds, because that's kind of what the industry was like before. It was very much the companies, especially companies with legal departments, were seen as being solely responsible for issuing legal holds. And again, the Tellermate case was one where it showed the court was looking to outside counsel to be more active and to acknowledge that they have more responsibilities around issuing legal holds correctly. So this is how we got here, not just around the legal holds, but how we get to the ethical considerations that are there as well. So that being said, I will turn it over to Barry, who will talk about the FRCP and the ABA model rules as well.
Well, thank you, Brian, and hello, everyone. The first rule that we want to speak about is the FRCP Rule 26, which was recently amended, as Brian mentioned, at the end of 2015. And this rule in particular puts the onus on the attorney who is certifying the discovery requests, the productions, the document productions, the requests for productions, and so forth, that they are true and correct. And as Brian was mentioning, it's incumbent upon us, the certifying attorneys, that we know what it is we're certifying to, and that information is correct to the best of our knowledge at the time we're making that certification. And there are consequences, obviously, for not having done that work, because there can be the imposition of sanctions and adverse inferences to the opposing side. This rule also has the effect of addressing proportionality, so that in an ethical consideration, the concept that when you're making requests of the other side or certifying to requests, that what you're doing is true and correct and is appropriate. You don't want to be overstretching in terms of overbroad discovery requests if indeed that's not something that is needed for the matter at hand. And the next rule that we want to talk about is Rule 37E, which had a major overwrite during the amended FRCP. The old rule was considered a very broad safe harbor provision that worked to allow for the normal loss of data through no fault of anybody except the operation of a system. So if a database updated automatically and certain data was lost, so be it, no harm, no foul, and parties could move on. The new rule, however, and I'll state this clearly. It says, upon finding prejudice to another party from loss of the information, the court may order measures no greater than that necessary to cure the prejudice. And the notion here is that the courts now have a broad amount of discretion in determining what a potential sanction might be, and it's incumbent upon the attorneys involved to make certain that the client can provide the appropriate information. One other side note with respect to this particular rule, there was a difference of opinion between a couple of the circuit courts, and this rule clarified that so that there's permission of issuing an adverse instruction only upon finding that the party acted with the intent to deprive another party of that information for the use in litigation. And I should note that this rule specifically addresses ESI. And there is commentary from the ABA that they would like to see the rule apply to all discoverable information, but to this point, not aware that that has actually been accepted anywhere. And one other comment with respect to the notion of the safe harbor, and I'll read this section because I think it's appropriate. The new rule applies only to electronically stored information, as I said, and it applies only when the information is lost. But remember, it's possible that given the way electronically stored information exists today, that it is around in multiple locations. So if one custodian's data is lost, it's possible that another custodian has it elsewhere, and that is an acceptable method for identifying and locating that particular information. And now let's move on to the ABA rules, which they're more broad in notion, but they play a very important role in the ethics of managing litigation holds and attorney responsibilities. And the first rule is that one of competence. And simply stated, an attorney in Model Rule 1.1 should possess the knowledge, skill, and be thorough in preparation and be reasonably informed to be able to represent your client. And the state of California has stated that if you're not up to snuff with respect to understanding technology, which ESI is replete with, then that in and of itself can be deemed unethical action. So it's incumbent upon attorneys as they're going through preparing for a case that if they don't have the proper skill set, that they need to make certain that they have members of their team that do indeed have that skill set. And then the second rule here, 1.3 regarding diligence, is simply that an attorney shall act with reasonable diligence and promptness in representing a client. If you miss a filing date, you're not being diligent. If you're not attentive to the detail of the case, have you identified all the possible sources for ESI and other data that might be relevant to the matter? You could be in violation of this particular ethical requirement of diligence. And Model Rule 3.4 discusses being fair to your opposing party and their counsel. Pardon me. You should not unlawfully obstruct another party's access to evidence or otherwise withhold, destroy, conceal, or prevent the other side from seeing what it is that they're supposed to be entitled to see through normal discovery. Falsifying evidence, I mean, that's a clear ethical violation, and it should never, ever, ever be done. And you should also be aware that if a court has a set of rules and requirements for their particular courtroom or jurisdiction, that you're aware of those rules regarding discovery, regarding evidence production, and also involving how depositions and other activities occur within that particular tribunal. And lastly, you shouldn't be making frivolous or inappropriate requests or activities that don't have a place in the court. And then the organization is your client. If you're representing a corporation and you're also involved with corporate officers, the CEO, president, vice president, whomever, and there becomes a difference of responsibility between the corporation and what the various employees, officers of the corporation are saying and doing. If there's a split, remember it's the organization that's hired you, and it's your obligation to represent the organization. And if there is that type of split, you should advise those parties that there's a contrary opinion, a contrary position, and they should seek a different and separate representation.
And Barry, I'll just jump in here really quick and make a comment. One of the things I've seen this used as an example for is, for example, if you go in and you talk to the general counsel of your client, and you see that they either don't take action to issue a legal hold or don't really think that it's worthwhile, you can't really stop there, is what this model rule says, because the GC of that company isn't your client, although it's an incredibly difficult thing. Like some of the other stuff you'll see here in a second, like ignoring your partner if you're an associate, you still have a responsibility to the client. It's one of those things where the model rules could potentially put liability still on you if the company doesn't, or a particular officer of the company says, oh, we don't need to issue a legal hold, or oh, we've got that handled, or oh, our document retention policy covers that, or some of those things. You really can't stop there. That you should go to a senior officer or even potentially the board of directors. It's hopefully something that most people don't face, and it's not something that I think a reasonable GC would kind of ignore in today's climate. But this is another place where probably unsuspecting there could be ethical considerations that arise from what outside counsel does in those circumstances. So sorry to interrupt, Barry.
And,
oh,
that's fine. And actually the Pomerone case that you mentioned earlier directly addresses that very issue, where the general counsel was lax and slow in issuing and maintaining a litigation hold, and that effort should have been escalated up to more senior management, either the CEO, or if that's not available, the CEO is implicated, to the board of directors. And then Rule 5.1 discusses the responsibilities of partners and managers and supervisory lawyers. What this means in a sentence is, as you have assembled a team of attorneys and staff to help you with a given matter, it's incumbent upon you to make certain that your team members are up to the task, that they're knowledgeable in whatever it is they've been tasked to do. If they're expected to know where the electronically stored information is located, if they're expected to know who was put on litigation hold and who the potential custodians are in a matter, that you're on top of it to make certain that that is taking place, that the proper interviews are occurring, that the proper documentation is being maintained. Excuse me. And then likewise, if you're on a team and you're not the senior member, you still are bound by the rules of professional conduct, and you in turn could be found liable if you haven't followed those rules. There is a sort of an exception to that, and it's Part B, where the rule states that a subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. And lastly, and this goes back to the point that Brian was just making with respect to the responsibilities regarding non-lawyer assistance. If you've asked somebody who is not an attorney to assist you in a meaningful way for a matter, it's with the knowledge that that person is going to do what it is you're expected to do, to have done, and do it in a reasonable and ethical and responsible manner. And again, and that extends to, as in the Pomeroni case, the GC, but it also extends to any vendors that might be retained to assist in collecting and processing data, any experts that might be hired, and so forth. And at this point, Brian will now go through some of the pertinent case law that's come up over the last year or so. Brian?
Thank you, Barry. Yeah, so hopefully, if you've been kind of following along so far, we've talked about why legal holds are such an issue, the case law that is now starting to lay that responsibility at the outside counsel's feet, as well as the corporate counsel as well. Has always been laid there, but now it's extending to the outside counsel. And between the FRCP and the ethical rules, show where that kind of liability or responsibility, and then therefore liability, comes from. What we're now going to talk about is how do you make sure that you're living up to those obligations? How do you actually make sure a legal hold is issued in the right way so that you don't face any of these problems? And we start out with the case law. We're going to talk a little bit here about some prominent cases that hit on the various steps of issuing a legal hold so that you can see, once we then in the next section talk about how to actually go about issuing those legal holds, kind of where a lot of those requirements come from. Now again, this isn't meant to be a comprehensive overview of the entire universe of legal holds. There are a ton of cases out there that talk about various aspects and various requirements. The point here really is to give you some great examples of each one of the different points from case law in the last several years, and then that leading into then showing you how to go about it. And again, if anybody didn't hear me to begin with, I'm about to show you pages of block text on various cases. So don't worry about copying it. You'll have a chance to get this presentation yourself, so you don't have to take notes. I guess before I get started, here's another number, 240, for those people who are tracking CLE in various locations that this counts for CLE credit. Again, the number is 240. Okay, so this case is the case I always start out with. It's Apple versus Samsung. Even though it predates the federal rules, it really still kind of followed what eventually became codified in the federal rules. I mean, that shouldn't come as a surprise. The federal rules weren't just created by somebody out of, or the federal changes to especially Rule 37E weren't just created out of thin air. It was kind of following the precedent that had started to develop throughout the course, although as Barry mentioned, there was a little bit of divergence there. I do believe that the Apple case here would have been decided exactly the same way under the new federal rules. So what happened in this case? Well, it started out with motion for sanction, motion to compel by Apple against Samsung, went to the magistrate judge, and who generally is the one handling a lot of the discovery disputes. And Apple claimed that Samsung had really not taken any steps to properly issue a legal hold and to really take the initial steps in that process. And among other things, so for those of you that have been sleeping under a rock, the Apple versus Samsung case was Apple going after Samsung for billions of dollars, that's billions with a B, in claims regarding the patent infringement, saying basically that Samsung was copying the iPhone. And this case has been in news for years and years and years, and it ended up in huge liabilities, some of the biggest liabilities and judgments in patent history, probably, I would assume. But this really talks about what happened before the trial. And right before the trial, Apple made a motion asking for sanctions against Samsung, saying that not only were they able to show that they were missing data, like there were big gaps in data, but they were able to show that Samsung didn't issue a legal hold for months after the case was filed. And this is despite the fact that months before the case was even filed, Apple had taken a whole cadre of attorneys over to Samsung and had a meeting with Samsung about their claims and their concerns, and said basically, if you don't cut it out, we're going to sue you. And Samsung didn't cut it out, so they sued him several months later. But even after that lawsuit was filed for, I think it was 3 or 4 months, Samsung still didn't issue legal holds until well after the case was underway. And just as importantly, and probably more importantly, they didn't suspend their email deletion policies. And their email deletion policies were very, very short, a matter of weeks, that if you didn't save your email, it would get automatically deleted. And that's one of the things we're going to talk about later on. And so Apple was able to prove all this, and the end result was the judge came out and said that they were going to issue an adverse inference. Basically, when I say adverse inference, and we'll talk about that throughout, generally the adverse inferences are that the jury can decide that the data that wasn't produced would have helped Apple prove its case or would have hurt Samsung in defending its actions. So they could make that adverse inference. And that's a pretty serious adverse inference because it kind of lets you prove the case without proving the case. And so facing that, and that was a great thing, and the judge goes through very, very great detailed explanations, and it's a really excellent case to read. If you don't read any other cases in this entire list, I highly recommend these because even though these came out before the Federal Rule 37E was changed, it's probably one of the best written. It goes through all the different steps and all the different requirements, and it's a very readable case as well. So I highly recommend that. So anyway, so Apple won initially with the magistrate judge and got this adverse inference sanction. Samsung, of course, appealed to the district court judge, and on appeal to the district court judge said, first off, we think the magistrate got it wrong, but even if the magistrate got it right, Apple didn't do any better. Apple didn't issue a litigation hold. There were similar gaps of email from senior executives at Apple because they hadn't issued a litigation hold in a timely manner. And so long story short, the district court judge said, okay, well, you were both bad actors. I'm going to dial back the adverse inference, but I'm going to tell the jury, I'm going to give that instruction against both of you. And faced with kind of mutually assured destruction, of course, that instruction was never given to the jury because it kind of was a wash. And so what I like to do is call this as one of my mother's favorite saying as I was growing up, what's good for the goose is good for the gander, or, ye who live in glass houses shouldn't throw stones. Choose your metaphor or your saying that you'd like to choose there. And it really goes to show, not just as a great example of what steps and kind of a very well-reasoned opinion by the judges who wrote both opinions that is a great read and a great example to hold up there. But it also sets up that example that a lot of people don't think about, which is, this isn't just for one side. Both parties have to live up to these requirements, not just for the defendants, although defendants tend to be the targets of these motions more often than the plaintiffs. And it's just a great, great overall read. Now, and again, if you don't read any other cases, I highly recommend these. Now, there's another case that I'd like to use for comparison purposes. Recent case, GNetCom versus Plantronics. You've probably seen this. It's been written a lot about because it was a recent ruling that came out about 2 months ago now. I don't want to spend a whole lot of time on it because it doesn't really fit into what we're talking about here as closely, but it's a significant case, so we wanted to bring it up. But what happened in this particular case was the defendant had, on a motion for sanctions by the plaintiff, basically the defendant had done everything right when it comes to issuing a legal hold and maintaining that legal hold. They had identified custodians. They issued the legal hold months before the complaint was filed, as soon as they had an anticipation of litigation. They had routine reminders to their custodians to make sure they remembered that they were on legal hold and it was still active. And they even went as far as doing something that I rarely ever see anybody do, which was to hold training sessions, actual training sessions for their custodians so that they understood what their responsibilities were. So I think it's, even though there were sanctions, and I'll talk about those in a second, I think it's a great example of, and the court even acknowledges that when it comes to issuing the legal hold itself, the company did everything right. And unfortunately, when it came to actually taking steps to preserve the data, which I mentioned is the kind of next step in the process, they had an executive who was a senior executive and an executive that the court at least found to be kind of central to the claims here, who had gone ahead and deleted information anyway. And while there's some dispute, and there's a lot of facts in this case, and we could talk about this case forever, I don't really want to get into that because it's more about preservation of data than legal holds. the sanctions there were pretty significant. And not only was there an adverse inference, but there was a multi-million-dollar punitive sanction as well. It'll be interesting to see. I don't want to spend a whole lot of time on that because I don't think this is over. It's very different than any other cases that we've seen. Adverse inference sanctions aren't unusual. The punitive sanctions like this, in light of the new rules and kind of in comparison to the other cases, like in Samsung, they had deleted data like crazy across everybody, not issued a legal hold, and all they got was an adverse inference, really. I think they had to pay some, originally we were going to have to pay some costs of the motion. But this one went way beyond that. So it'll be interesting to see whether or not it continues and whether or not that part of it stands. But it kind of goes for two things. First, it shows how a great legal hold process should go, but it also shows how that can be derailed if you don't pay attention to it. Not pay attention, I shouldn't say that. If you have a rogue actor who doesn't kind of follow those things and how to deal with those. So anyway, that being said, let's talk about the next one. The case here, Baker versus Community Health Systems, is a very interesting case because it was one of the only ones we saw that really targeted the actions of the plaintiff. And here it was the plaintiff was the U.S. government who didn't take steps to issue a timely legal hold and identify key witnesses and kind of follow the whole process. But the reason I point this out is because, again, this isn't just for defendants. So much of what we hear about, so much of what we hear written about focuses on sanctions against the defendants in a case for not doing something, but the plaintiffs have to be very careful as well, and make sure your own house is in order before you start looking at what the other side is doing. And that even goes for individuals. I've seen cases where sanctions have been leveled against a single plaintiff who was bringing a case against like an employee-employer dispute or a former employee dispute. So it's very, very important. Carelessness can result in sanctions as well, although the Rule 37E kind of changes what the sanctions might look like, but because it really does bifurcate the difference between carelessness and intentional conduct. But I still think this ruling would largely hold up even after 37E changes. In this case, they didn't take proactive steps to maintain documents and suspend normal deletion policies, notably for both paper and electronic. Now, Barry mentioned before, Rule 37E is really about electronic. It says electronically stored information. Doesn't necessarily mean that the same concept can't be used by the court. It's a question as to why the court did that, or why the rule was invented to only apply to electronically stored information. But this is the case where the court looks at paper as well. And so in this particular case, it was about the defendant, Ventura Corp, didn't take steps to stop normal deletion policies, not just with their electronic documents, but their paper as well. And the court, didn't find any bad faith, but noticed that there was evidence handled, and it was careless nonetheless, and issued sanctions to help correct that. And I think, again, under Rule 37E, you would have a similar result. This is an interesting case, EOC versus JPMorgan Chase, because it points out you have to think about your triggering events within your organization and figure out where those events might occur so that you can put in place measures to make sure you identify those. So in this particular case, the EOC had notified JPMorgan Chase of a potential dispute. But for whatever reason, those kind of notifications of a potential employee dispute got routed probably more through HR than through legal originally. But for whatever reason, that particular event didn't end up triggering a legal hold. And JPMorgan Chase definitely has a legal hold process in place and solutions in place. But for whatever reason, this particular complaint, before it became a lawsuit, when it was just an EEOC inquiry, didn't trigger a litigation hold. And because it didn't, data was lost, and because data was lost, sanctions were issued. The point of this is you need to look within your organization and figure out where are those triggering events most likely to arise. If you're a product company, if you're producing products, maybe it's in your complaint department, maybe it's in your design review, whatever the case may be. You need to look at your organization, figure out where are we most likely to see complaints. Or when a new lawsuit comes in, go back and say, okay, well, where did we first hear about the rumblings that became this lawsuit, so that you can figure out within your own organization. It's very organization specific. Who do you train and make it part of those employees' training to identify when potential triggering events happen and to at least notify the legal department or whoever is the legal liaison if there's no legal department within the company. So it's a very important part of identifying it. The next step, and these three cases I'll just zoom through really quick. At the end of the day, what this is talking about is you can't wait. If you remember in the Samsung case, I said Samsung waited for months after the case was filed, even though they knew months before the case was filed. This Major Tours case, the plaintiffs there waited for 4 months. The defendants waited for 4 months after the complaint was filed. And you'll see these other cases are very similar. You can't wait that long. It's much better. You need to get the litigation hold notice out there as soon as you have a reasonable anticipation of litigation. And these are some cases that really go into details that show you, what happens if you don't do that right away. And when we get to the how-to section in a second, we'll talk a little bit more about that. But these cases really are highlighted for that particular aspect. Custodian identification must be comprehensive, and this is something we'll talk about as well, and this is kind of where it comes from, or a great example of this particular issue. The point is you can't just gloss over identifying the right custodians. In the case here, the LSI Corporation case, the problem there was that there wasn't a very good effort done to identify custodians, and of course key custodians were missed. They weren't put on legal hold. They didn't take steps to preserve their data, and so data was lost and sanctions resulted. Kind of the same story, but here it was about it wasn't that they didn't issue a legal hold. They did. They just didn't go in and try to figure out the right people. And so kind of similar to the Palmieri case as well. It was the CFO was handling it, didn't really go in and identify the right people, didn't really give the right notice. Very similar idea. So it's very important that you identify custodians, and again, we'll talk about how best to do that here in a minute. And last but not least, there are a couple of more decisions here, the recent 37E decisions. The courts really do have the discretion. As Barry went over, there's a big difference now between what happens if there's bad faith or not, and making sure you take these reasonable steps. So the Brown-Jordan versus Carmichael, the defendants failed to preserve the email. The court really quoted and through 37E in its entirety, and it explicitly found bad faith, and then because of that weighed all the notions and its power to impose sanctions under Rule 37, and it's a great decision that kind of pulls through and looks at Rule 37. The Martin Transfer Court is another one that looked at it, but in that case found that the information that was sought to be preserved was some Internet history that by the time it was identified in 2015, the Internet history from 2013, for those of you who don't know, Internet history kind of is a very kind of temporary thing. It gets overwritten and falls off over time. By that time, the Internet history was gone anyway. And the court going through it found, look, there was no bad faith. There was no even kind of understanding that this was the type of information that they would need. And so in 37E, looking at that, decided that no sanctions would be imposed. So these are two rulings that have come out recently this year after the new rules were put in place. And if you'd like to look at how the courts looked at 37E particularly, these are two great cases to look at. So that all being said, in the last quarter of our presentation, we're going to talk practical guidelines. Barry and I will both talk a little bit about this. I'll start out with the first couple of slides here. One of the things we talk about is if you're before you even get to the point of figuring out what your legal hold process should look like in a particular case, you need to think about this before you find yourself in that situation. It's the old adage, the best defense is a good offense. You got to plan and prepare for the eventuality of a legal hold. Hopefully you're not first thinking about how to do a legal hold when you get that first case that pops across your desk or the next case that pops across your desk. Planning is key because planning is really what helps make sure the legal hold process goes off correctly. What we recommend to companies is create a legal event team that has the right resources, both internal and external. You want to make sure that team gets educated, that they're discussing things like triggering events and attending CLE presentations like this one and lots of others. You want to figure out how you're going to distribute the legal hold. Is it going to be a manual process? A lot of companies still use Outlook and or emails and spreadsheets to track their legal holds? Are you going to use a different process? If so, get that in place. Make sure it works. Make sure that everybody understands that this is the process you're going to be using to issue legal holds. Figure out who's going to be responsible. Who's going to be identifying the custodians? Who's going to actually issue and track the legal hold process? And what kind of automatic suspensions do you have to worry about? Do you have auto-deletion policies that need to be suspended as part of the legal hold process? And finally, knowing your resources. So these are kind of things, again, you want to have these questions answered before you ever have to worry about issuing legal holds, because if you don't, you're going to be scrambling around and the entire process is going to be much more difficult. And I've used this slide in lots of different presentations. So it's not just about legal hold, it's about how to get started on the right foot in general.
Brian, let me interject one thing. If you go back to the prior slide, if you could. The legal event team itself, the construction of that, if you notice what we have there, we have a representative from the legal department, IT, HR, as Brian was discussing the Chase case. If there's an HR representative available, perhaps the sanctions in that case wouldn't have happened, as well as an executive sponsor. You need to have that executive sponsorship that provides legitimacy to your legal event team as it's being created and as it's functioning. I'm sorry, Brian. Go ahead.
Oh, I guess I'm talking to myself on mute there for a second. And I went too far. So, Barry, I know you talk a lot about triggering events. You want to talk about what is the most important thing before you even get to issuing a legal hold is when do you have to issue it, right? It's what kicks off the process.
And you know, the third bullet point on the page is when litigation is reasonably anticipated. And given the nature of your company, your organization, if you're a manufacturer of medical devices, when a person makes a claim that medical device has perhaps caused an injury of some sort, you're on notice immediately that there's a likelihood of litigation coming. The same with the product malfunction. Look at the General Motors with the ignition switch issue, or Takata with the airbags issue. Product malfunctions, those are clearly triggering events. And as Brian mentioned again, and I mentioned with respect to the Chase case, HR cases, HR matters, whether it's harassment or other working condition questions, many times, and we've seen this through many different matters for our clients, we see the types of events that cause rise to likely litigation. IP infringement, again, the Apple-Samsung case. If you're going to be prosecuting your intellectual property against a potential offender, when you know that you're going to be doing that, that's the time to start the legal hold process. Likewise, when you get the notice of a potential intellectual property claim, you're on notice to protect yourself with issuing a proper litigation hold. And accidents, I think, are clear on their face. If you receive a claim letter, if it's from an attorney, obviously you're on notice, but if it's from a consumer or a user of your product or service, you're also possibly on notice. And obviously, notice of a regulatory investigation, a claim letter, a civil investigative demand, a request for an interview from an enforcing agency, those have the tendency to put you on notice of the need to issue a proper litigation hold.
And it's interesting, Barry, there that that you see those are a lot of examples. But one of the things that I always tell clients, I've had people come to me before and say, "Well, here's what's going on. Do you think we should issue a legal hold?" And my answer is, if you're asking me, then probably yes. It is because issuing a legal hold late can have such severe ramifications, and because the actual act of issuing a legal hold itself is generally, especially if you put the right planning in place and the right systems in place, is generally relatively straightforward. Err on the side of caution, And one of the examples I've always give there is several years ago, we had for our software a patent claim filed against us, which ended up being dismissed about a month later pretty quickly because it was a patent troll that had absolutely no application to the software. And even though we knew that, the claims were completely bogus, we put people on litigation hold. We put our employees on litigation hold, and specifically, we'll talk about this in a minute, we didn't tell the employees, hey, we think this is a bogus claim, because it's the last thing you want to do is put out a legal hold and then nullify it through your own language. But even though we knew that it was a claim that would go nowhere, that it had absolutely no implication to our software, and that they clearly hadn't even looked at the system to make the claims that they did, and in fact it got dismissed, like I said, a month or two later, we still issued a legal hold because it is, you just don't want to get caught on that process because who knows, the case could have gone forward for a little bit, and the last thing we wanted to do was face an issue of whether or not we had issued a legal hold on time. And so the triggering events, it's a real balance. There's no bright line there, but what we always tell people is err on the side of caution. So in this list here, you see the steps to a successful legal hold. We're going to go through each one of these individually on the next several slides. But Barry, you want to run down the list real quick?
Certainly. The first step, and I think we mentioned it earlier, is to identify potential custodians. It's easier to put a person on hold early and then make the determination later on that that particular individual doesn't need to be a custodian. So we advise to cast a wide net, but don't make it too wide. You don't want to blanket the entire organization unless it's an organization of 5 people. You want to identify those persons who are really involved with whatever the issue is at hand. And one way to identify that is to have some interviews of the key personnel who can also assist in expanding the net to the appropriate additional people. And don't forget here Rule 34, which talks about, for a custodian, that person that's in possession, custody, or control of the data that you're looking to preserve. And then you need to write the legal hold. And it should be clear and concise. And as Brian was saying earlier, the differences between Zuber Lake and the Chin case are, it may not be required by court decision to put your hold notice in writing, but we think it's best practice. There's no error. There's no room for doubt if it's in writing. And then appropriately distribute the hold to those persons who you've identified as potential custodians. And how you distribute it, it should be in a reliable and verifiable way and tracked in a very defensible manner so that you have a clear audit record of when the hold was written, when it was sent, who received it, who acknowledged it, and so forth. It may come into question. We have a little presentation towards the end as to whether or not legal holds are discoverable. And then through the pendency of the hold, it's important to, as we say here, maintain the hold. That means to remind your custodians that they are indeed on hold and what their obligations are with respect to the hold. Pardon me. And part of that obligation is newly created information and data is also subject to the hold. And lastly, as I said, maintain a clear and concise record of, pardon me, of the hold. Brian, could you take over for a sec?
Yeah, I was going to say, Barry, I'll let you get a drink of water here, and I'll take over for a little bit. So we're going to dive a little deeper into some of the individual steps. And the first one here is really, once you know you have the legal hold, the first step is, like we talked about, identifying who should be on it. And how do you go about doing that? Well, the easiest one is start with a complaint. Look, who are the people who were named, if any individuals were named, or who are the departments that were implicated? Is it a design defect implication? Is it a medical, something about a particular drug if you're a pharmaceutical company, or a particular transaction if you're a finance company? Look at that stuff and try to identify not only the people who might be named, but also their managers, and then talk to those people, talk to those custodians. It may seem pretty straightforward, but it'd be amazing how many times simply picking up the phone and asking those custodians who they know, who were involved, tell me your side of the story, kind of name names, so to speak, but not necessarily put them on the spot for that, but just start talking to them. And again, don't forget third parties. Like Barry mentioned, it's under your custody and control. The case on the previous slide talked about how outside vendors and outside consultants and advisors, you are responsible for putting them on legal hold if that data is in your custody and control. The Tellerman case was a great example of that because the court there said that the plaintiff was required to maintain data in Salesforce, and Tellerman came back and said, well, it's not our system, it's Salesforce's system. What can we do about it? And they actually lost because the contract with Salesforce, like so many of these contracts for online systems, very, very clearly said, the data is yours. You own the data. We do not. It is completely yours. And so the court latched onto the contract itself and said, you guys own this data. It's your responsibility. You should be maintaining it. And that's what they ended up being sanctioned for there. So we always tell people is don't be afraid to start putting, issue that legal hold. Get it out there. Courts would much rather see you get a legal hold out there very quickly to the people that you can identify, because you can always change it. You can add people to the legal hold. You can remove people from the legal hold if you find out that they're not really actors in the case. There's nothing wrong with changing the process. It doesn't have to be perfect. And in fact, there's a lot of case law out there in e-discovery that talks about no one expects perfection because perfection is impossible. People are imperfect. Humans are imperfect. No one expects perfection. They expect you to be diligent. And the best way to be diligent is to get that out there and to identify custodians very quickly. And again, don't forget about exited employees. When you're not only when you're first issuing a legal hold, to look to see if there are any recently exited employees that may still have data out there, especially stuff that might be getting ready for recycling. But just as importantly, if not more importantly, if employees are on legal hold and exit during the legal hold process, make sure that you have a process with your IT team or HR team, who's ever responsible for kind of recycling an employee's resources, for them to be able to check a list, if nothing else. A spreadsheet saved on the network somewhere if you're not using an automated system, where they can see, is this employee on legal hold, and if so, take proper steps to make sure you maintain it. That's a big black hole in a lot of organizations and a place where a lot of people get into trouble because they just don't think about it, and it's understandable. The next thing is, should it be in writing or not? I think now, this was a bigger issue back in the day, and you can look at some of these cases that talk about whether something has to be in writing. The Chin case came out and said, like we said earlier, Judge Shillen said if it wasn't in writing, that was de facto negligence, and the Chin case came out, the Second Circuit said, well, maybe not. The Chin case didn't say it doesn't have to be. It just says we're going to take that into consideration. And what we tell clients is, look, if you want a fully defensible process, if you don't want to be standing in front of the Second Circuit to say why you're a proper exception to the rule, so to speak, then just put it in writing. Absolutely put it in writing. Yes, there's no absolute legal requirement that across all cases, if you can see different jurisdictions say different things, be on the safe side, put it in writing. And when you put it in writing, you want to be clear and concise. You want to answer the questions. Why was the legal hold issued? Who's subject to it? What should be preserved? How should it be preserved? Where should it be preserved? When is the legal hold effective? And very, 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 very important, provide a contact person in the legal hold notice itself. Do not include legalese. If it reads like a contract, you're doing it wrong. I always tell our people, when we issue legal holds internally, we've only issued a couple and nothing that, usually for subpoenas or something. We do them in the format of an FAQ. Why am I getting this? What should I do? And answering those questions for people. Do not put any legal analysis of the claims. Again, the last thing you want to do is say, oh, this isn't important because X, Y, Z. You don't want to let management will want to tell their employees this case is a complete, waste of time, yada, yada, we're going to win. Do not put that in there because it will negate, it'll downplay the importance of that, and it'll really take the wind out of the sails there. The next thing is, we got another number here. For those of you that are tracking these numbers, the number is 262. Again, it's 262, and I believe that's the last one we're going to have. Communicating the how to custodians, what you want to tell them to do, this is pretty straightforward and simple. Tell them, make sure you read and acknowledge this notice. Very top, make sure that your opening sentences, this is very important. It's very important you read this. It may be a long notice, but please take the time to read it. Make sure that you have process in place to suspend deletion policies. And a lot of times you're going to ask custodians as well to identify where they store data. That gets into custodian questionnaires that we'll talk about here in a second. Make sure you tell them, don't delete files, don't copy files, don't even move the files. Just leave them alone. Don't go through and feel like all of a sudden you've got to organize all your stuff, because You might be changing metadata when you do that, and you just don't want to go there. Just don't delete stuff and wait for further instructions. And then the last thing is this management idea, right? Distributing the legal hold, maintaining the legal hold, having an audit trail. These are pretty straightforward. Like Barry said, you want to make sure you have a reliable, verifiable, and defensible process for sending it out. Like again, that could be something as simple as emails and spreadsheets. Now that gets very overwhelming very quickly if you're tracking more than 1 or 2 legal holds. But something as simple as that is absolutely fine. But make sure that it's verifiable. In other words, you can't just post the legal hold notice to your employee bulletin board. You have to make sure that the employees acknowledge that they got it. Whether you go around and ask every employee that you gave a legal hold notice, hey, did you do this and sign something? Or you have them send back an email, or you're using an automated system that they can click a button to acknowledge. You want to make sure that you acknowledge the legal hold, because just sending it out without acknowledgement isn't going to be enough. You want to make sure you've got it defensible. Maintaining the legal holds, although there's not a legal requirement per se to send out reminders, cases today go for years generally. You want to make sure that you're sending out reminders. Usually we see people do it once a quarter, once a year, something like that. And finally, the audit trail. You want to make sure that you're tracking all this stuff so that when you get called to the carpet on whether or not you did this, you have that information. This is just a quick overview how we do it. You can see here, and it's probably hard to read on the slide, but the kind of information we track: when things were sent, when they were acknowledged, when the last reminder was sent out, if the custodian was released, things like that. These are the types of things you want to remember and keep track of. 2 last slides, and then we'll get to some questions if we have any. The last question really is, when can custodians be released? Really, it's when the event is concluded. It's that classic when there's a settlement or final distribution. If you find out a custodian is non-responsive, then let him go. Or if you can agree with the opposing counsel who your custodians are, you can let the others go. And again, this brings up the importance of reminders and keeping the custodians reminded along the way. And last but not least, are legal holds discoverable? There's a number of cases here. Again, this will be in the presentation that you can ask for. But the simple fact is, generally speaking, the legal holds themselves are usually considered attorney-client work product or attorney-client privilege documents, and will not be released. But the who got it, when they got it, if they were reminded, and what they did in reply to it, and what they actually did once they received it, are things that can generally be asked about. And there are some exceptions. If there's concerns of spoliation, if there are concerns whether or not the advice was correct, then you might have to produce the actual litigation hold notice itself. But generally speaking, those are not reviewable. So sorry to kind of go through the last couple of slides quick, but we're running out of time, and I wanted to make sure we had time for questions. Barry, or I'm sorry, I think Mark, you might be the one that was going to tee up the question.
Yes, I'm gonna manage that part of it. So thank you very much, Brian. There's a reason why this is one of our most popular webinars, and I think people just understood again why. The content is great, the message was great, well done. So we have a ton of questions. We're out of time, so we are going to go ahead and respond individually to people who have asked questions through the website. However, there are a couple quick ones I'll throw at you, Brian. The first one is, what's a reasonable time frame to send a reminder?
That's a good question, and it kind of depends on the case and your custodians. But what we tell our clients is you really should do it at least once a quarter. And especially if you can do it through automated systems, it becomes very simple. You just kind of, a lot of these legal hold solutions are set it and forget it. But once a quarter is great, but I would say at least once every 6 months. We see some companies do it as often as once a month. And the other thing I would say is, think about your audience. If you have people who are core to the case, you might want to remind them more often than people who are kind of secondary or kind of tertiary custodians who might not have been involved. You might not have to remind them quite as often. So, but I would say if you want a very safe thing, once a quarter is the best.
And one more. Once you've done a full collection for all your custodians on a case, is it okay to remove them once you've collected their data?
That's a great question. And I don't think I've ever seen a judge really kind of address that, because I understand the question is, is it okay to let custodians look, hey, we've made a copy of everything in the universe. My answer is don't release the legal hold, and for 2 reasons. Number one, we've all been involved in cases where as the case proceeds, oh, you find out that there's other sources of information, or there's more custodians, or there's other locations that nobody talked about at the beginning of the case. I mean, how many times have we heard in depositions a custodian who's answered a custodian questionnaire and been interviewed mention a source of data that they, or a source that they store information that they never told anybody about before. And so for that reason, plus the fact that the federal rules of civil procedure and most state rules are similar, your obligations for discovery are ongoing. So as new data is created over time, that data should be preserved as well. So I think it's great if you have that ability to copy all your data, or you've got an archiving system that copies all of your emails as they go in and out of the organization. It's a great way to make sure that you're preserving that information and protecting yourself. But I wouldn't use that as a defense. I think the closest parallel I can do to that is I've seen cases where no legal hold has been issued because the company said, hey, we have a document retention policy that is just rock solid. And courts have said, sorry, no substitutions here. You still have to issue a legal hold. You didn't issue a legal hold, so thereby you're going to get sanctioned. So I think that kind of is the closest analysis.
All right.
So
we're going to end it there and thank. Yes, we are going to end it there and thank everybody. We've gone over. Our apologies for that, but certainly hope it was time well spent for everybody on the line. There's a short survey, just a couple of questions. If you'd like a copy of this presentation and or a copy of the due conference amendments to the Federal Rules of Civil Procedure, you'll have an opportunity to request those after answering the short survey. Thank you very much. We hope to see you again online next time. Have a great day, everybody. Thank you, Brian. Thank you, Barry.